The next one will be on November 17th, so mark your calendars now for that one at 7 p.m. And I just wanted to tell you a little bit about the Autism Program of Illinois. We were founded in 2003 as a public act through the General Assembly to meet the, at that time, increasing needs of children being diagnosed with autism, which were like one in about 150 in those days. So the Autism Program of Illinois is funded by grant funds from the Illinois Department of Human Services. And then we take those funds and turn them over to our partners across the state. So I'm not going to read our mission statement. You can see it there. So we have 15 partner organizations, 4 universities, and 11 other partner organizations across the state of Illinois that work with us to provide an array of services, including screenings, diagnostics, treatment, individual therapies, group support groups, group therapy, and a lot of education and training. And so that's kind of what we're doing tonight. Our TAP Central office, the administrative offices are located in Springfield, and we put on a number of trainings as well. This is one of them. And then many of our partners throughout the state do trainings for their regional areas as well. So we're really excited to have you. And it's nice to not be dealing with election coverage, right? We're going to get into some IEP discussion tonight. One more thing where you can find us is on our website. Forgive us for right now. We are building a brand new website, which is super fabulous behind the scenes. It will be that same URL link that you see right there and is to launch very soon. You can also find us on Facebook and Twitter. And we are creating a new YouTube account where all of our trainings will be posted. But these trainings with our friends at Breaking Autism are on their YouTube channel as well. So you will be able to find them there. And I'm sure Sabrina will let us know where that is as we go along. So without further ado, I am going to turn it over to Sabrina and the rest of the team at Breaking Autism.
All right, thanks. And hi, everyone. Very nice to see you. Happy Election Day? Question mark. Nonetheless, we are very excited to have you here today. We know that there's a lot going on, and only more continues as the week evolves. So we know that there's a bunch of schools doing things right. Today, we're going to talk about what happens when things aren't necessarily going right. It's not to say that all schools are doing it wrong, but there are some things, some options that you should know about, your rights and best practices that you should know about in the event that you are running into a dispute with your school. As you know, if you haven't met the Breaking Autism team, my name is Sabrina Shafer. I'm a special education attorney. I have a fairly extensive background in behavioral analysis and working with organizations like TAP and several organizations across the state and nationwide. With me, I have, as I always say, the one and only Mr. Phil Milsk. You've heard me talk a ton about him. If you're on the video podcast or paying attention to anything Breaking Autism, you know that he is such a wealth of knowledge. He is a former hearing officer for the Illinois State Board of Education and a special education attorney, and just crazy knowledgeable. And of course, the one and only Miss Judy Ruffalo, special education advocate for 20 plus years. I always like to tease her on that one. I'll let you guess how many pluses there are. ISB, so Illinois State Board of Education facilitator for IEPs, for facilitated IEPs. She's a mediator. Again, just an amazing wealth of knowledge. We are going to go through quite a lot today because what would a Breaking Autism webinar be without a ton of content? We're going to run through that. We're going to talk about things around prevention. How do you really prevent special education disputes, if at all possible? Two, and this is sort of an escalation type pattern or type mode here. So two, how do you handle IEPs and facilitated IEPs as it relates to special education disputes and resolving them? Three, we'll talk about mediation and some best practices there, really what your rights are there, and some nitty gritty. We're not going to get into things like TAPE as much today, but stay tuned for some of the upcoming sessions where we will. We'll talk about agreements, just the fundamentals to agreements, because some parents are reaching their own agreements outside of an IEP. So let's talk about what that looks like, what you should know. We'll talk about due process. You know, that's a crazy hot topic. Give you some resources and some upcoming events. And then, not to be overly ambitious, but that's what we do, we'll try to answer a couple of Q&A. I do advise, I know we're going to talk about a lot today, as we always do. If you have questions that come up throughout the conversation or throughout the webinar today, you're welcome to post your questions in the chat, and we'll try to address those as we go. If not, we'll try to make some time at the end and address them. So without further ado, let's dive right in. I'll have to see if Phil, are you, were you able to jump on?
Yes, I'm on. Hello, everyone.
Right,
do you want me to go over this real quickly, Sabrina? That's fine. I will. So as you know, right now we're in a public health emergency situation due to COVID. And since last March, we've had a number of governors, emergency proclamations and guidance coming from the State Board of Ed. We've had an omnibus bill passed in the Illinois General Assembly. For those of you in Illinois, I know some of you may not be in Illinois, that puts into statute some of the things that the governor had directed as a result of COVID to protect public health, including the remote learning days and blended remote learning days. And we've had some directives or guidance documents coming out of the federal U.S. Department of Education. The upshot of all that is that districts are trying to do what they can do best to deliver educational services under the current circumstances, keeping in mind that they have to try to act in the best interests of students and staff with regard to public health and families as well. But the rights in regard to dispute resolution that we're going to talk about are exactly the same as they were before. There have been no changes. There are no waivers of any of the procedures that we will discuss tonight. So if anybody tells you that things are different because of COVID-19, that is incorrect in terms of the procedures that are available to you. Except for the one caveat that, at least in Illinois, and I don't know about other states, but I would imagine similarly in other states, hearings and mediation sessions are being held remotely in most cases, and so are IEP meetings. So Judy can address the IEP meetings a little bit more, but we just wanted everybody to know that there are no legal changes with regard to these procedures.
And that's so important. So this is the takeaway. So if you have to drop off, if you have dinner, if you're just fired up about the election, whatever it might be, this is it. If you walk away with nothing today, it's really understand your rights to free, appropriate education are the same. As Phil mentioned, your resolution options are the same. And the fact that every case, right, that a child's IEP is based on their individually unique needs, all of that remains the same. So I know there's a lot of confusion going around about remote learning plans and things like that. A remote learning plan does not change an IEP. It's very important that you know the difference of that, and we'll unpack it a little bit today. We unpacked it a lot in our previous session, which, as was mentioned earlier, is up on our YouTube channel. So thank you, Phil. I'm glad we got that sort of disclaimer or takeaway out up front. So let's talk a little bit, Judy, about prevention. What can families really do to prevent special education disputes?
Okay, so obviously, you know, when we talk about conflict resolution, we don't always think about prevention, but it is really, really important. I always tell parents that, you know, this relationship that you have with the district is kind of like a marriage that you really can't get out of unless you pack up and move. Otherwise, you know, they're your district and you are stuck there. So you need to do your best to try and make that work. Sorry, I'm having a little bit of difficulty with my screen here, so I apologize. So in any case, I mean, in any relationship, obviously the number one rule is good communication. The thing that we would tell you is you need to express your concerns early. Don't sit and wait for something that's kind of eating at you to just blow up, because you're going to get more frustrated as time goes on. You need to deal with it right away. Bring it to the attention of the case manager. Do what you, you know, just do what you can to keep that line of communication open and work through problems before they become too large. The second issue of family engagement, maybe you've never heard it referred to that way, but this is actually a huge topic. There's been books written about it if you're interested. But the bottom line is really that there's been a lot of research into the outcomes of students who had parents who were engaged with the school district. And so that means just being involved in the ways that you're able to, you know, within the construct of your busy life. Okay. So, you know, participate in fundraisers if you can. Try to be that person that, you know, one of those parents that when the principal walks past you, he knows exactly who you are. And you might, you know, it's about relationship building. I mean, I want to say you might find that you get treated a little better in a meeting, but it really comes down more to that relationship, that you really are building that with the school. And then finally, just collaboration and problem solving. Again, you know, this is a rule of thumb. Anytime you are part of the solution to a problem, you know, the more likely you're going to buy into it and you're going to do your part. So, you know, when you're at a point of dispute with a school district, I would say be actively involved, listen to what they're saying, and try to come to the table with solutions. I'm not saying it's entirely your responsibility, but it's probably in the early stages not a good idea to dig your heels in unless it's something really, really important. You know, we always say that, you know, make sure that's the hill that you want to die on. So I think the main things I just want to stress are, if there's a problem, don't wait. A lot of times you'll hear a district tell parents, well, you know, let's see how your child does next quarter, and then maybe we'll talk about that again. And that might be appropriate for maybe one quarter, but it's not appropriate for much longer than that. Do not let your child get too far behind. Try to stay involved and be sure that you monitor your child's progress and that you're keeping up with that.
That's such a good, you know, the fact of really monitoring progress. And by the way, Judy has an amazing video out there on the Breaking Autism YouTube channel on how do you monitor your child's IEP progress. And we use an example so you can see exactly how you monitor it and how you track that progress. So that's another example. You hear us talk about, you know, leverage data, where parents have more data than they realize. So it's one really powerful tool that parents can use as part of the prevention stage, if you will. So Phil, before I go into IEP meetings, anything you would add to the whole, the idea of how you really prevent a special education dispute?
I'm on mute, I apologize. The only thing I would point out is that what I always used to tell parents is, you know, your child, and Judy kind of alluded to this, when she said, don't, you know, don't jump the gun in terms of going, for example, to due process unless it's absolutely necessary, because your child has to go to the school unless you're planning on moving. Your child has to go to the school, and you need to be getting along with and sharing information and collaborating with these educators to the extent possible in your child's best interest. So it's in my view, it's always best to try to resolve disputes. We know there are going to be disputes that cannot be resolved without going either to mediation or due process, but try to do it if it's possible, because it's better for your child and it's better for you. And it may be down the road, there may be a dispute that gets to the point where it can't be resolved, but anything that's resolvable, I would highly recommend that you do it informally through the IEP process.
Yeah. Which is the perfect segue to how do you do that formally through the IEP process? And if you've been on any of our webinars, our workshops, seminars before, you know how much we harp on parental input, and it's because it's such an under-leveraged tool that parents and guardians have as it relates to keeping a record, keeping track of what your parental input, like your concerns, data, your child's needs, where that can all go. And so, of course, there's different resources up on the website and on the YouTube channel to help you really break down how do you write parental input. In fact, we've got one out there where we literally break down and kind of go through a best, better, the right way, the most appropriate way. So really understanding how do you utilize parental input. And a lot of times that includes preparing it ahead of time, which I know we don't have a ton of time as parents, but it's something that's so incredibly valuable in part, and I'll just go through it briefly, because as a member of the IEP team, your input should be considered as the entire team is building out your child's present level of performance. And the present levels of performance make up the IEP goals, which make up the IEP itself, placement, minutes, everything. So if you don't have a solid foundation, it's impossible to build a sturdy house. And part of that foundation is parental input. So add things like your concerns, add things like new data points, right? And your child's needs, especially now as you're noticing. And by the way, you can call an IEP meeting at any time. You can call one IEP meeting for one IEP, or you can call 7 IEP meetings for one IEP. The idea is to call as many IEP meetings or meetings as you need based on your child's unique needs. And you'll hear me say that a bunch of times because it's so important for parents to know that it's based on your child's unique needs, right? So number 2, IEP, as Phil mentioned, is really the first step in resolving disputes. Before considering, mediation and other resolution options, which, like I mentioned, we'll talk about today, and sort of that escalation path, if you will, consider calling an IEP meeting first. Really understand your data before you get to that IEP meeting. In Illinois, you are required now to get documents 3 days in advance. I know I need that. I know I need to really read and process things, ask questions, provide information to private team members, like private OT, speech, those kinds of things. So consider calling an IEP meeting, and consider preparing as much as you can for that IEP meeting, in part preparing your parental input. And last, at least for now, because I know we're trying to cram a bunch in today, as we've talked about, strive for agreement. And the thing I would add there is, you've heard us talk about this before. There's an entire continuum of options as it relates to special education. There's such a blend and a hybrid that's offered, or at least should be offered to children, that don't limit yourself. Really get creative when you're trying to reach an agreement. What we recommend, and we'll get this into this a little bit deeper into the agreement section, is really looking at the holistic problem. Really looking at, is there something that holistically would address these various issues that are coming up, assuming you have more than one. So as we talked about, right, my background's in behavioral analysis, so I love data. Try to use the process, the data itself. If you know something's not working, don't repeat an IEP goal. just because of COVID. And understand your rights. Attend things like this meeting. Email us questions. We promise we always respond. Make sure you're networking with your parent network to understand what other parents are doing. But really understand that there's an enormous amount of benefits that arise out of IEPs and the rights that's sort of embedded within that and under the IDEA. So make sure you leverage those kinds of things. So with that, Judy, before we kind of move on, anything you would add to that as it relates to IEP meetings?
No, I can't really think of anything. I guess, if the emotions get too high during an IEP meeting, I would say you probably should suspend the meeting and reconvene because, and that does happen. And it's okay to do that. It's okay to stop the meeting and get back together because usually when you do, everyone is being a little bit more reasonable and respectful. So
that's a very good point. And I hope if you are taking notes, write this down. You can stop an IEP meeting at any time. So typically there's someone taking notes, or there should be, right? You can stop at any time and ask them to read the notes back. And if you don't think that reflects your comment, your statement, your parental input, whatever it might be, you can stop and address that. If there's questions that you have, if things are going really fast, if things are getting contentious, you can call another meeting. You can ask for 5 minutes. There are no rules against that. So thank you, Judy. That's a great call out. That's a great call out. So with that, let's talk about facilitated IEPs. They're a little bit different than IEPs, but still an IEP nonetheless. So Judy, walk us through what that really looks like and advantages around that.
Sure. So facilitated IEP meetings are a newer option in Illinois. And in this case, as in many others, both parties have to agree to participate in a facilitated IEP. So the district and the parent, it can't be one or the other. They both have to agree. Now you can request a facilitated IEP right on the ISB website. That's the Illinois State Board of Education. It's a free service. And what happens is a neutral third party actually comes in and runs the IEP meeting instead of the district running the meeting. So the facilitators are, they're skilled in dispute resolution practices, and they can guide the IEP meetings in such a way that it really ensures that all the parties are heard and that all the decisions are truly agreed upon by everyone in the room. I know that sounds kind of wild, but there is a process to it. You can have multiple facilitated IEP meetings, just like you can have multiple IEP meetings. I want to clarify one thing though that's a little bit confusing is that the facilitation process itself is being used in a lot of different school districts right now. And that really means that the district has had staff that have received training on how to follow the agenda of a facilitated IEP meeting. But what you really need to know is that is not the same thing as a state-sponsored IEP facilitation, okay? You might come in to a meeting and they might, a lot of times I hear them say, welcome to Joey's facilitated IEP meeting, and they go through the process, but there isn't an actual facilitator there. So there's a difference. So you want state-sponsored facilitation and you need to request that through ISB, okay? What else? IEP documents from the facilitated meeting are still legal. They're still enforceable through the traditional complaint process with the state or for due process. And, there is that caveat that protects the facilitator. You cannot call your IEP facilitator as a witness in a due process hearing if you should end up going to due process. So if you're having some difficulties with your district, you might want to try a facilitated IEP meeting. It can be really helpful working through some of the tougher issues, and a lot of the feedback that the state is gathering on the state-sponsored facilitation is very positive. Parents see this as a real valuable tool, you know, to get through those meetings that they feel are so challenging. So that is really an IEP facilitation meeting in a nutshell. So I don't know if you have anything you want to add.
No, I think you hit it. It's, you know, you're still walking away with an IEP, but the process itself is facilitated. Yeah, no, I think that's great. So
Yeah, I just
just
had one question
sure.
for Judy. I just was curious as to how frequent the state facilitation is used, would you say, just in terms of like a percentage of meetings?
You know, I wish I knew that number, quite honestly. I think that a lot of districts feel now that they've been trained in the process that, you know, they like the process and they're using it, but it's still not the same as having, you know, that independent third party running the meeting instead of, because they're actually, what I've never seen done in a district facilitated meeting is having them work through the problem solving process that's taught and that's used by facilitators to come to agreements, even if it's not the most popular choice, but it's a very specific process of, you know, these are the options, and there's brainstorming, and there's, you know, okay, we don't love this one, but can we live with it? You know, it's a very involved process. So I don't see that happening so much.
Right.
I think it's becoming more popular, but I also do know that sometimes districts will refuse a facilitated IEP,
Right.
which is their choice, you know.
Right. Well, moving on to mediation. So mediation is a process that each state is required to have under federal law. Each state has to have a mediation process. It is voluntary on the part of the parents and the school district. So if the parent wants to go to mediation, but the district does not, then there's no mediation, and vice versa. So both parties have to agree to mediation. You appear before a neutral third party who's a trained mediator who works under a contract with the State Board of Education. They can't be a district employee, and they are not an advocate for either party. They are neutral. They are trained on how to conduct a mediation. The information that is disclosed in a mediation is not admissible in a due process hearing, and the mediator cannot be called as a witness in a due process hearing. So basically the process is established for the purpose of trying to get the parties to reach an agreement, and it's not supposed to be used for the purpose of gathering discovery information to use at a hearing. Although some parties can sometimes try to do that, but kind of in a slick way. So yeah, kind of in a very slick way. So you can have an attorney at the mediation, and either side, and you know, the mediation is free, except if you're hiring an attorney. Of course, the attorney will probably charge you for their time at the mediation. And you know, the idea is, again, as the slide indicates, is to find common ground. Sometimes the way it usually starts is the parents will present their issue or issues and what resolution they would like to see, and then the district will respond, and then the mediator usually has the district caucus in a separate room to talk about what else they might be willing to offer, and then they come back in, or the hearing officer will convey from the district separate district meeting what the district may offer, and then the parents can respond. The idea is to reach an agreement. The agreement is enforceable. It's a contract. It's enforceable in a court of law. If you sign a mediation agreement, you get 72 hours to rescind your agreement. So like most consumer laws. You sign the agreement, you have 72 hours to back out. And once you've resolved through you can also have a partial resolution in a mediation. Let's say that you have multiple issues in a case. Oh, and I should mention, you can use mediation even if you're not in due process. You can use mediation totally separate from due process, or you can use it if you're in due process, either as an alternative to a resolution meeting, or you can use it in addition to a resolution meeting. If the resolution meeting is unsuccessful, you can use mediation as well. But you can have a partial agreement where, let's say that you have a bunch of issues, including an IEP issue. You can have a issue with regard to the district's evaluation procedures. You could have an issue with regard to this child's placement. And the district may agree in mediation to conduct some new evaluations. And then once those evaluations are done, they would agree to go back to a meeting to determine, whether they would make any of the changes that you want based on the evaluations. That would not resolve your hearing if your hearing includes all those issues, but at least it gets you a little closer, and you've got new evaluation material to work with. So I used to be a hearing officer, and I know that in a number of my cases, I would be told, well, we've reached an agreement in mediation to do new evaluations, but we want to keep the case going because we haven't resolved all the issues yet. So that can happen as well. So that's kind of all, it's a very valuable procedure. And again, there's no cost other than, the cost of maybe taking a little bit of time off from work to attend, or to do it remotely, which a lot of mediators are now doing remote mediations because of COVID. And if you have an attorney and you want your attorney there, you'll probably have to pay your attorney unless you have a legal aid attorney or Equip for Equality or someone like that representing you. So, Sabrina, you got anything else you want to add to that?
Yeah, I think a lot of times I get asked, well, when should I attend mediation? When is that a good option? If you feel like your school district is working in good faith, as we talked about earlier, sometimes the parties are just at an impasse and you have to go to hearing, or you have to do something else, get an evaluation, get some more data points in order to really understand the situation better. But as Phil mentioned, a lot of times you can find common ground. And in a mediation, at least myself personally, that's what I'm looking for. Okay, what's really at the heart of district interest? And as we'll talk about in just a minute, how can we really resolve the issue or issue as much as possible? As Phil and Judy has mentioned, when you're part of the solution, a lot of times it tends to work in your best interest, or ultimately, obviously, the child's best interest. So that's the only thing I would add there. Yeah, I know a lot to cover, but a mediation can be very powerful if both parties are truly working in good faith.
Yeah, there are some very excellent mediators, and because of retirements and the fact that they've had more mediations recently in the last maybe 2 years than they were having before, they've hired some new people who I think, I know a couple of them, and I think they're very good at what they do. They're experienced attorneys who've practiced in the field, and they know what they're doing, and they know how to run a mediation. They've had experience with mediation. So there are, I think mediation is a good process in most cases. And if usually if the district suggests that you go to mediation, that would tend to be a signal that they're really looking to try to settle. It depends. I mean, it depends on the issue, and yeah, I mean, if they offer to go to mediation, usually, and a lot of the district, Sabrina will probably agree with me, there are attorneys that work for some districts that are really looking to settle matters, and some districts are looking to settle matters. There are others that are not quite so interested in settlement, but we kind of know who those are. So
Which
yeah.
ones? No, I'm just kidding. Just
No,
kidding.
I'm not naming names now.
Just kidding.
No names.
Yeah.
I know.
You got to have a little fun with it. Yeah.
That's right.
No,
That's
I
right.
agree. I completely agree.
Right.
So, as it relates to mediation and also some of the other things that we've talked about today, the end goal, right, is to reach an agreement. Now, ultimately, if you're able to reach an agreement in an IEP meeting, that would be in the IEP itself. But sometimes what you have to do is reach a negotiated agreement. And in that case, there's a lot to unpack there. Frankly, way too much to cover, even if we had the entire hour dedicated. But we know that some parents are reaching agreements right now with their school districts outside of an IEP. And so we wanted to cover sort of the quick hits, what you absolutely have to know as you're kind of entering into what we call a negotiated agreement. So first and foremost, you've heard us say a couple times, so don't forget it, get creative. As Phil mentioned, sometimes you're able to resolve a piece of the overarching issue, or sometimes you're able to resolve all of the issues at hand. So a lot of times, and if there's attorneys on the line that have worked with me in the past, they know that this is true, or families. What I like to look at is, for instance, if there's a free and appropriate education issue, an issue with the child's existing or current education not being appropriate, and maybe some past failures where the child needs some really intense interventions or things like that, I try to see if there's a way to pair the two together so that it's cohesive for the child, because you don't want to run disparate, interventions unless it really makes sense for the child. And a lot of times there's just not enough hours in the day. So you're also looking to drive a more cohesive calendar so that you get things like generalization of skills, right? Quicker mastery and retention. So it's really important that you're looking at the entire needs of the child and see if there's things that you can bring together, even multiple issues that you can resolve together. That includes things like busing issues, right? Goal issues, services minutes, things like that. There really are, if you can think it, it's a possibility when it comes to special education. Hybrid schedules, hybrid interventions, related services, especially now as we're getting more creative with things like assistive technology, which I love. I wish we could spend 12 hours on that alone. So make sure you're not limiting your child by not fully vetting out your options. If you have questions about what is a therapeutic day school, like I said, reach out, ask questions, make sure that's documented, that you're asking those kinds of questions, because if it didn't happen in writing, it didn't happen. I know you've heard me say that to you a billion times. There are some pretty common components to an agreement that you should know about if you're going to reach an agreement with your district without an attorney involved. It's common language. It doesn't mean it's always the case, because as we talked about, you can, in agreement, you can settle one issue or multiple issues or every issue that's at hand. For instance, the example Phil gave, you might agree to a private evaluation. Maybe you realize that your child you need more data on where your child's really at to help prioritize goals and services or placement. And if that's the case, you might reach an agreement to have a certain evaluator do the evaluation and then reconvene an IEP meeting or something like that. So depending on the situation, there's going to be common language. First and foremost, most of the time you're going to see a clause that includes no fault. One thing that I always say is make sure that your clauses are mutual. So if there's a non-disclosure clause, which means that you're not going to communicate what the contents of the agreement is, make sure that it's mutual, that the district's not going to disclose that. If there's a waiver of claims, meaning that you are waiving all pre-existing claims that you might have against the district, make sure the district is doing the same as well. So anything like that, you'll often see things like clauses saying, neither party is admitting fault. That's another one, that if it just says parents are not admitting, district's not admitting fault, make sure that parents are protected in that as well. But just understand that for the most part, districts are going to try to settle everything possible if you get to the agreement stage. So they're going to say things like, you're waiving all existing claims, whether known or unknown. So understand that that's a component, and what that means before you sign anything. And last but not least, something you should know if it's not already obvious, typically, not always, but I would say 95% of the time, negotiated agreements are not done in an IEP meeting. Typically what happens is they're done behind closed doors with administrators. You'll see, you know, the superintendent, assistant superintendent, or some kind of supervisor of the special education department. So sometimes they're called the special education coordinator. There's all kinds of titles, but you're going to want to talk to the person who really has authority to make a decision in an agreement. So I know we covered a lot, and I'm seeing some questions pop up here, at least a couple on my phone already. Judy, Phil, anything you would add to that?
Well, the only thing I would add when you're talking about waiving claims, from the district's perspective, they want to make sure that they're not going to be to leave hanging any potential violations that may have occurred prior to the date of the settlement, but they cannot preclude you from filing in the future for any future violations that may occur after the date of the agreement. So if they tried to do that, it would be unenforceable. It would be invalid because they can't take away your right to use due process or any of these other procedures in the future. But they do want to make sure that they're covered as far as anything that may have occurred prior to the date, up to the date, I should say, including the date of the agreement. In exchange for that, of course, you're getting something. Otherwise, it wouldn't be an agreement. As Sabrina said, it could be a related service, could be increased minutes, it could be a different placement, it could be changes in the IEP that you want, could be new transition services or activities, could be an evaluation or two. So you're getting something in return that presumably you've requested in the past, you know, for previous infractions that you're now they're now willing to give you in accordance with this agreement. So I know parents get offended by, you know, oh, why am I giving up rights? You know, it's like, well, you have to. That's what an agreement is. You give up something, you get something back. Right.
Right. And I just noticed there's a question in the chat. This relates to remote learning as well. So if your district is not doing in-person learning and you reach an agreement, in fact, we have 2 cases going on like this right now, where in both cases, the child has a visual impairment, physical and learning disability. And so the district is not in person right now, but we're reaching an agreement to provide in-person services. So that's an example where you would reach an agreement that might look different. And then that might be included in your IEP, right? That might be something that gets added in. So I'm sure there's more to that question. There always is. So if we have a couple extra minutes, we can hang on and answer that in more detail for you. So let's dive into due process. Phil, I could think of no other expert on due process than you.
Well, we could do due process training and it would take about 2 days, but we'll try to stay within our 3 or 4 or 5 minutes. And you can chime in, Sabrina, whenever you want to. So due process is a procedural safeguard under IDEA. Each state has to have a due process hearing system. And as we have in Illinois, some states have a 2-level administrative process where you have a hearing level and then you can go to an administrative appeal to your state agency. We used to have that about 20 years ago, maybe a little longer than that, but we changed to a 1-level system. So due process is really your shot at the apple. It's the only evidentiary hearing you will have. It's like a trial. It's a legal proceeding, and you make a request, and your request has to have some basic information in it to be sufficient. And that includes stating the problem as it relates to your child, and then stating a proposed resolution, or prayer for relief, as we sometimes call it. And commonly, you know, and as we've got on the slide, the common issues are child find. They didn't conduct child find, so they didn't identify my child as having a disability. Child find and evaluation, at least initial evaluation violations are usually the same issue. Like, you didn't do the child find because you didn't evaluate my child. But then you can also have evaluation issues going forward with regard to reevaluations that come up at least every 3 years, if not more frequently, where you're identifying flaws in their evaluation process. And then you get into this whole issue of trying to get independent evals or private evals if you want to go out on your own, if you can afford to, or you have insurance to pay for those. You can utilize private sources and bring those back to the team, and they have to consider those. So that could be an issue. Placement is a very common issue. Where should my child be educated, or what type of placement along the continuum? Unilateral placement, very common issue for some parents who are fed up with their lack of progress that their child is making, and they want to move their child. Usually it's to a private school, sometimes residential, sometimes day school. And they will unilaterally place the child there and then seek reimbursement for the cost, either back payments and prospective payments, or just prospective payments. And so that is a fairly common issue, as is identifying parts of the IEP that are improper. Goals aren't written right. The goals don't focus on the right areas. The present levels are bad, which usually goes back, as Sabrina or Judy had said, I think, the present levels are really the critical piece, because they flow from the evaluations and any observations that are done and any testing that's done. And then they translate into the goals. And if the present levels are not written well or not determined well, you really, and we see this a lot, you really can't have measurable goals. And if you don't have measurable goals, then it's hard to monitor progress, because you don't have any measurements to base progress on. So we see all kinds of good, bad, and indifferent IEPs, and they usually stem from the fact that the evaluations weren't done well, or the present levels weren't written well, and then that ends us up with bad goals. So parents want to raise those issues sometimes in due process. It's an evidentiary hearing, meaning it's like a trial. So parents can represent themselves. There are parents that file pro se or on your own behalf. Very difficult. I was a hearing officer for 6 years. I presided over a number of pro se hearings, which generally resulted in me taking over the questioning, which we can do if we feel that the hearing isn't moving along, or the parents are just not focusing on the right questions based on the issues they've raised. We can take over a hearing and ask the questions. I had a whole hearing where I did that. Gave the dad a whole day to ask his questions, realized the hearing was not moving along in the direction that it should have been moving, and said, I'm just going to ask all the questions, and then gave them a chance to ask additional questions once I was done. And we moved it along, and we got to the issues, and actually the parents won that case. So there's some advantage to doing that sometimes. But I would strongly recommend having an attorney if you can at all afford one, or get one through either low cost or no cost, because especially one who has some experience in this area, and there aren't that many attorneys who do, but you got 2 of them on the program tonight, and there are a number of others, but they're not real plentiful around the whole state. I would say, in terms of Illinois, you're going to find most of the attorneys in the Chicago area, I would say, that do special ed work. Having a good advocate like Judy, and there's a number of others advising you, is also helpful. They cannot practice law if they don't have a law license, but they can help you, kind of guide you through some of the things and assist you. So they are allowed to participate. Some hearing officers who are my former colleagues some of them don't have an appreciation of the role of an advocate as they should have, but a good advocate can really help a parent kind of get guided through this process. But it is hard to represent yourself, I will say. Then you ultimately, in a due process, you get a decision in writing that is supposed to lay out the findings and conclusions and determine what kind of, or issue an order as to what the district should do, must do, and it has to be pretty specific. We used to get a lot of orders that from hearing officers that were very non-specific, like go to another IEP meeting and try to work it out. Well, you don't want to sit in a hearing for 5 days and then come up with an order that tells you to go back to an IEP meeting. Could have done that on your own. What you want is the hearing officer to say, based on the evidence of the case, this is what I'm ordering to be done, and be pretty specific about it and have a time frame within which those things have to be done. One example would be district will conduct an assistive technology evaluation of the student to determine their AT needs within 60 days of the date of the decision, either on their own or through a private contractual arrangement. That would be a specific order. They could even get even more specific if they wanted to and say it should focus on communication skills or should focus on reading and writing or whatever is appropriate for that student. You can always settle a due process, and you can go to mediation after you file for due process, and many of the mediations that are held while the due process is pending. You can settle privately and enter into one of those private settlement agreements that Sabrina talked about while a due process is pending. So there are a lot of different ways you can resolve a matter. Hearing officers do encourage parties to settle. And I would say roughly, I'm going to give a rough guess, 90% of the due process cases that are filed are settled before a hearing. I know that I had years as a hearing officer when I only had one hearing, and then I had 1 year when I had 8. So that's a lot. It's a lot for a hearing officer to have a hearing like 7 out of 10 months in the year. That's because a lot of them last 3 to 5 days or more. And they're pretty intense and they take a lot of work. There's a lot of, depending on the child's needs, there could be a lot of information, a lot of records to pour through. Lawyers, whoever's litigating the case has to be really organized and know the case, like any trial. Prepare your witnesses, try to figure out know who your witnesses are going to be. And sometimes that takes, a lawyer to sit down with the parent and figure out who's been involved with the child, not only at the school level, but also in the community, and, doctors, therapists, psychologists that you've gone to, social workers, tutors that your child has had, maybe a witness, all sorts of folks. It's a trial. You can call people as you see fit. The one procedure that I mentioned, every case, before you go to hearing, you have a pre-hearing conference where you have to disclose who your witnesses might be and what records you might be putting into the record, what exhibits. You do have a right to get records and to review records, and as Sabrina will attest, and Judy as well, sometimes you can't get records, all the records that you need on your first request, and that's disturbing and troublesome to all of us who, the district has an advantage in that the records are generated by the district and by their employees and not by us and not by you as a parent. So you're relying on them to be honest and straightforward about the fact that they're giving you a complete record. And then we have to go through them. And sometimes that could be going through thousands of pages to figure out what's missing, if anything's missing. Sometimes you don't get emails. Sometimes you don't get, all the IEPs sometimes. Sometimes you don't get all the internal memos that may or, and then there's some things that may not be records. They may not be student records. But that's why it's good to have a lawyer, because the lawyers are supposed to know, what it is they're supposed to be provided. So it's a complex process. Certainly you can do it on your own. but it's difficult. It is difficult. And, you know, the hearing officers, depending on who you get, are not always particularly helpful to the pro se parents. But, you know, we were trained to be, just that some of them just are not particularly inclined to be helpful. That's all I'll say about that. But anyway, it's a complicated subject that would probably take a whole day at least to go through all the ins and outs of due process. But I hope you got a decent general idea of what it's about.
Exactly. And stay tuned for some of the upcoming sessions. We also have a lot of coffee chats and wine chats, which we should have done a wine chat today, being election day and everything. But where we have an open chat and you can ask me your questions. Again, if you have some immediate questions, you're welcome to email us. In just a minute, I will throw up the email addresses so you can email us. Real quick, let's go through our top 3 takeaways and then answer maybe 1 or 2 questions and then we'll all hop off. You've heard us say it a couple times, but you hear things 7 to 11 times to remember them. So communicate often. If you've heard us say it once, you've heard us say it a million times, write it down, send an email, try to keep your own records. It's still talked about. There could be complications with records. And the more you have the data, the more empowered you are. So try to do that. Number 2, use data to make sure that the resolution really aligns to what's appropriate for your child. You know, make sure that you're really using your own data. That includes things like taking video recordings, taking pictures. Now you have a ton of data because you can see in person what your child's able to do or not able to do. So make sure you're using that data and take advantage of your options and your rights. I know a lot of parents feel defeated right now. There are ways to get yourself heard. You have a ton of options. We've talked through some of them today. I know quickly, but at least a little bit more in depth. And make sure that if you really understand your rights and you leverage your options, that you're networking and talking to other folks in the special education community because we can help each other. So with that, remember, as we talked about, if you learn nothing else, understand your rights have not changed. They are the exact same prior to the pandemic. So an IEP must be based on your child's unique needs. That's it. It must support and help them in their education, including future education, independent living, and further employment. Understand that as well. If that triggers something, you can check out some of the past resources. Make sure you check out some of the upcoming resources we have coming up. So if you're looking for things like sample letters, other videos, some upcoming blogs, check out breakingautism.com. You've heard us talk about the video podcast. In fact, the last video podcast was on how do you represent yourself in a due process case, and that is done by Mr. Phil Milsk himself. You can check out the YouTube channel for other content and things like that we constantly have coming up. You can find us on Twitter and Facebook, Breaking Autism, or sign up on breakingautism.com for our newsletter. And real quick, some upcoming sessions. The next one is going to be on fundamental rights. So really breaking down, understanding what are your rights, what's that IEP process, an overview of the rights, and some advocacy tips, some must-knows. Then we're going to talk about, you have to attend this, send this to everyone you know. How do you monitor IEP progress? You have to watch that a billion times because I wish more parents do that. And then we'll walk through procedural safeguards. You know that giant packet you get at the end of the IEPs? We'll talk about what that actually means. So with that, we're going to open it up. I know we're over, so we're just going to do 1 or 2 quick questions. But while we answer those questions now, I'll also have our emails up so you can email us afterwards if you have any questions. So with that, I'm going to open up the chat and see what kind of questions we have.
There was one question, Sabrina, in the Q&A about where parents might find the data collection template to use at home. Do you have that on your website?
As far as how they can collect their own data? Mm-hmm. Yeah, you know what? I can throw that up on the chat. really what I would do is what works for you. There's a couple different templates out there right now. What I would recommend, in fact, Judy, I don't know if you're able to do it real quick, is if not, I could throw it in the chat, is check out the video on how to track IEP progress. Every parent is different on how they like to record and log data. Honestly, the best thing you can do is keep emails. So send emails to the district and either print them out or put them in a folder and open up an Excel spreadsheet and just add in your notes. So I would add in the dates and what you've observed that day. So you might have, sent an email to teacher and speech about concerns with X, or this came back, and start keeping track of some of your concerns. But the biggest thing is, if you're communicating them with the district, is keeping those emails. So really making sure that you're learning how to write those kinds of emails is what I would focus on. I hope that answers the question. If you're still on, you can unmute and we can unpack it a little bit more if it did or it didn't answer your question.
It did. They say thank you.
Ah, good. Okay, good.
I think you also touched on the other question regarding remote learning not working, and if the Illinois Department of Public Health has the authority to keep school districts from offering in person when it's not working.
I can address. You want me to address that?
Perfect. Yeah, go ahead, Phil. Yep.
Well, it's the way it's set up now. It's up to the local school district, and public health has some guidelines that have to be followed if you're going to do in person. They go by, and then again, they're going by metrics. So the governor's office and the Department of Public Health are going by the Department of Public Health metrics in terms of which districts can open, where they can actually start opening up. And, but it's a determination of the school board, local school board. I represent school social workers, and one of the questions I commonly get is, how can I stop my school board from opening up our schools because we're afraid to go back? And that's been a major issue at Chicago Public Schools, especially where the union is really upset that they would open up schools. They're afraid of, from safety of the students, safety of the staff, and then they may catch something, take it back home to the family, and then the whole family gets sick. That just spreads exponentially. So, ultimately, the governor has taken responsibility using the metrics of the department, but currently it's up to each school district. But as the numbers grow, I don't know how what's going to happen from that point on. But right now it's up to each school board to determine what to do. A lot of them are using blended remote, so they'll stagger the days for kids, or they'll stagger the hours. They'll stagger staff hours. They'll keep physical distancing. Some of them are using PPE.
And it's PPE. Constantly moving target too, though.
It's constantly moving target, and we will admit that a lot of kids are not being adequately served by it. Yeah, and that may result in an onslaught of due process requests in the future, or even currently. I'm not sure what's going on with the requests, but in the future, parents may decide that they're going to try to seek some kind of compensatory services down the road.
Yeah, great question. Remember, your rights haven't changed, right? Your child is entitled to a free and appropriate education based on their unique needs in the areas of education, including further education, independent living, and employment. So those three categories. So make sure you remember that this is based on your child's unique needs. That's very different than general education, and that's part of the power of really understanding what the IDEA, which is the governing body of law in the law in this area. So really understanding what that means can be incredibly powerful, incredibly powerful. So with that, I know we are way over.
We have one more question. Can we do one?
Oh, we do. Okay.
We do.
So what if a parent is in negotiations with a district and agreements are made, but the district won't write it into the IEP?
Phil, you know I'm going to say something snarky. Do you want to take this and be civilized with it, or
well, it depends on what they've agreed to do. But if it's something related to services to the student, or placement, or number of minutes of a related service, it should definitely be in the IEP. I don't know why they wouldn't write it in the IEP unless they intended not to follow through. You know, is that what you were going to say, Sabrina? I mean, I don't know why they would
Well, I
not
was
put
going
it
to say,
in.
then you're not negotiating an agreement, are you? Then there is
Right.
no
Yeah, they're not-
agreement.
It's
I mean,
not an
willing
agreement,
to-
right? Exactly. I agree with you.
yeah.
I hear this a lot with specific curriculum. So a parent might get the district to agree to some type of Orton Gillingham reading program, but they're not going to write it into the IEP. They're going to write reading goals that can be implemented using any curriculum, as
Yeah.
it makes it difficult to enforce if the district makes a move to no longer use that curriculum, or if the parent moves to another district. That's where I usually see them, you know, kind of digging in their heels.
There's an old case, Judy. Well, I say old case, it's about 30 years old, where the Seventh Circuit Court of Appeals, which is our federal court of appeals, held that the district is not tied to a particular educational methodology.
Exactly.
And so this issue of using Orton Gillingham or some other program, they would argue that it's a methodology and we don't have to commit ourselves to using it as long as we're meeting the goals. And courts have upheld that. Yes. Again, it's back to the individual circumstances of the case, and what they're actually doing for the child and whether that fits into the child's IEP goals. But if it's a methodology issue, they would have some legal precedent to stand on to say that they don't have to put that in the IEP, if that's the issue.
If it's something else that they're not willing to put in the IEP that you've gotten them to agree to, my take on that would be that they don't want to be held to whatever that issue is that you made an agreement on. So,
which, by the way, just because they don't have to, we've been very successful in having it included in an IEP and been very successful in that. So I just saw the note, specific tutoring with methods.
Yep.
I would still ask for it in the IEP, because likely there's a training and support section in the IEP. It's likely that you need to have some kind of training and support related to this methodology, that if you move or if whoever was part of the agreement is no longer part of the IEP team, that would get lost. If they're willing to put it in the agreement, you might consider that okay. But I would push. It's very specific. You're welcome to unmute and we can kind of talk through it, but it sounds like it's something that probably should be in the IEP and probably in multiple areas. So probably the additional notes, probably in the additional supports and training section, and something like that. Oh, they did put it in vaguely in parent training. That's better than nothing. You'd be surprised.
What you can try and do if it's related to a reading methodology, and I'm going to assume that it's Orton Gillingham or Wilson, something like that, you can see if they would agree to putting it in some more vague terms, like a multisensory structured direct instruction. You know, you can kind of pull that off of the websites and put that. I used to know it by heart, but you know, they may agree to something that's a little bit more vague, but that's still going to because truly, I mean, and I taught Wilson for years, but another similar program with the same, you know, basic methodology of teaching a phonics-based reading is going to work. So I know a lot of times parents get real hung up. I want Wilson, I want Wilson. But, you know, the reality is there's others out there that are just as effective and shown to be so through research. So.
Thank you
Yeah, I think
all.
I know we could talk for hours on this, but I'm glad these are great questions. Yeah, thank
They're
you.
very
Likewise,
good.
thank you.
I'm glad so many people hung in there with us. I do want to remind everyone, if you've not done so, please fill out the TAP survey at the end of this training and indicate that it was provided by TAP Central Office. That allows us to continue to provide great trainings free of charge with our friends at Breaking Autism and others that we have. And tune in next time with Breaking Autism November 17th, and we're going right into December, aren't we, as well, with some more training. So thank you so much. I appreciate Phil and Judy and Sabrina so much. They're so knowledgeable. They will answer your questions. Email them with anything that you need. Find their resources on their website. Get their videos on YouTube. You will learn so much. Thank you all for joining.
Thank you.
Thanks,
Appreciate
everyone.
it.
Have a great day.
Yeah.
Okay.
Good
Bye.
night.
See you
Good
Good
soon.
night.
night.
Bye.